And welcome back to Daily Justice. I'm Dave Erickson. Our topic today is, can you change a prenup after your marriage in Washington State? My guest today is Mark Hodgson, family law attorney here in Spokane. Is it possible for couples to change that agreement once they're married under Washington law?
Yeah, I think you can change any agreement you make as far as both parties do so. The problem I have is, and I don't mind saying it, I say this to people all the time, I don't love prenups to begin with. I don't like prenuptial agreements to begin with because a lot of times they lay out things, and if the marriage has any duration or longevity, then what you own, if think of your own life, for instance, what did you own 10 years ago that you still own today? Oftentimes you don't own the same house, you don't own the same car, you don't own the same investment vehicles, your retirement has shifted, you've rolled a 401k into an IRA and all those things. So oftentimes what's listed in the prenup is simply not accurate going forward. So can you kind of get a do-over during the marriage? Yes, you absolutely can. You can agree to pretty much anything under Washington law. It needs to be done correctly, and it needs to have all the correct recitals and everything else as to how it goes. There may be better options than going back and amending and having all these documents along the wayside, because if you think about it, you start with let's say a prenuptial agreement, and then you go 10 years down the road and you do some post-nuptial agreement that addresses everything. Then 5 years down the road you change it. Then 5 years down the road there's all these agreements, and let's say that new agreement doesn't hit all the points of the first one. It really becomes very, very fraught with peril and really open to attack.
So the legal process can be lengthy, or is it pretty straightforward?
It's pretty straightforward, but it's kind of like a will in this regard of it's not difficult to do, but let's say you have a will and you lay it out, and then you have another will, and you don't destroy these wills. If there's ever litigation around your will, those documents can be incredibly deceiving. And in fact, if you don't have the most recent one and they use an old one and nobody can find the most recent one, then what controls? And it becomes incredibly difficult. So doing it over and over and over again can be fraught with peril. They need to be done perfectly if you're going to do that. However, there's another better option.
Which is?
Well, if you have, a lot of times a prenuptial agreement is made so that if you were to get married and you were heir to the Disney fortune and you had Disneyland, you owned Disneyland. And so that was your separate property going into the marriage. If you keep that property separate, you keep the proceeds from that property separate, and then you deal only with how you contribute to the marriage. Well, if you keep everything separate and don't put your spouse's name on it, by Washington law, that's your property, always. So that's a common misconception, is that people think that when you get married, everything becomes community. That's not true. Inheritance doesn't become community. Personal injury proceeds do not become community. Property that you took in before the marriage does not become community. So keeping those items separate can be more effective than multiple prenuptial agreements.
How about the enforcement?
Well, the enforcement's odd because if you have one like a year out or 2 years out, they're oftentimes very powerful because they're agreements that everybody made. If they happen 20 years out, the enforcement becomes much more problematic because the character of property changes. You simply, as you grow older, you commingle stuff, you get stuff. You don't, what's yours became ours, and money. And if both parties have contributed to a joint venture, it can become very difficult. So keeping everything separate is generally my first advice, and then a prenuptial agreement can come in very handy if you've got trusts and things like that. And if you're very, very wealthy here and the other person doesn't really have anything, a prenuptial can be very helpful. But over time, if you're say 30 or something like that, and you're into a 30-year marriage, the enforcement of a prenuptial agreement can be very difficult.
It seems like it would create some strain on the emotional element of the relationship to even bring that topic up.
I think so. However, again, let's say you own Jack in the Box and then you meet the love of your life who's working the counter. And let's say it's a real relationship and you both love each other dearly, and the other person there doesn't care that they ever get any of the Jack in the Box fortune because the Jack in the Box fortune is going to the kids and they just don't care. A prenuptial agreement can be very handy in that regard too, because then you can also provide like maybe a certain amount of money or whatever, both in your will and in the prenup to take care of that person down the road. But the other person, but yes, oftentimes if one party is asked to sign a prenuptial agreement,
It's like
It
there's a
can be
plan B
awkward.
that's hanging out there, right?
It can be awkward, but a lot of people understand it too. Like, just like maybe like if two parties were to get married and they'd both been married before, that's where a prenuptial agreement oftentimes works out very, very well. Because then let's say they got their house in the divorce, they got their house in the divorce. What are we going to do with these houses when we make one house? Those types of agreements make all the sense in the world, and everybody seems to like those. Those are great, because as long as everybody knows the score. If it's two 22-year-old kids for the first marriage, that's a tough conversation to have, and I think that's real tough.
It seems like what you mentioned, maybe the will is the plan B if you don't want to bring up the topic because, then we can say, you can have the Jack in Box fortune, we'll put it in the will for everybody else.
Correct.
If I pass away first.
Well, and as long as you kept it separate too, because you've really insulated it from them. Now, the belt and suspenders approach would be the will. Like, let's say you've got Jack in the Box fortune, and then this other person has nothing, and you want to give them $100,000 upon your death or something like that. Then a prenuptial agreement might be just the way to go along with a will. It's really got to look at the whole picture and to go, well, I did a prenup 25 years ago, I should be fine. I'm not so sure all the time. I mean, you're going to constantly be wanting to look at that, talking to a family law professional, going, where am I, out there, to simply rely upon it once you get a divorce 25 years after the fact. I think that's oftentimes not so great.
Mark, interesting topic. Thank you so much. For more expert legal insights or to get trusted help for your situation, visit HodsonLawOffices.com or call the number on your screen to schedule your free consultation today. There's also a direct link below this video.